So today we're going to be talking about the duties that a lawyer owes the court, part of the professional responsibilities a lawyer has towards the court. Now, the first we have is Rule 30 in the Rules of Professional Conduct, which says that the lawyer is an officer of the court, all right? So he's considered to be a minister in the temple of justice, and as such, he must not do anything that would adversely affect the administration of justice. Now, under Rule 31, we have rules governing the conduct of a lawyer in court. Now, lawyers are expected to always treat the court with respect. One way you see this rule being tested in scenarios is where, for instance, the lawyer is left in court with only one more counsel whom the court is supposed to hear on the day. Now, the lawyer who was heard before the last person has to wait behind until the court hears the last person and then they both depart. If you left without waiting for the last counsel to be heard on the day, and you'd be said to have undressed the court, and you're not supposed to leave the court undressed. So the lawyer should always treat the court with respect. If there are complaints to be made against a judicial officer, so that's like the judge, it should be directed to the appropriate authorities. It's not going to be very helpful to the administration of justice if the lawyer openly challenges the judge or seems to make any open accusations or insinuations as to partiality from the judge. Rather, the complaints should be directed to the appropriate authorities who would investigate and deal with such matters. And the lawyer is also not supposed to discuss pending cases with the judge except the other opposing lawyer is present. And because you know that it would have, again, the appearance of bias. It would seem as though the court is tilted towards one party against the other. Now, another important duty we have that the lawyer has toward the court is in respect of observing the order of precedence. And we find this under Rule 26, sub 2. There is an order of priority in the legal profession, which you find on the first schedule of the Legal Practitioners Act. At the top of the order of precedence, you have the Attorney General of the Federation, and then the respective state attorneys generals. And then you have, after that, life members of the body of benches. And then you have senior advocates of Nigeria in that order. So the lawyer is supposed to observe the order of precedence that exists in the legal profession. Now, under Rule 47, we have the duty of good faith and fairness, which basically states that the lawyer should avoid engaging in sharp practices. For instance, if you as a counsel have an agreement with the opposing counsel, you don't then go before the courts and pretend as though you have no knowledge of any such agreement you've entered with the other party. So let's imagine the other party has some emergency and for that reason could not be present, and you know of it, and he's called you and discussed it with you and wants you to help to inform the court on his behalf. It would be wrong if you went before the court and took undue advantage of his situation. Now, another very important rule we have is under Rule 33, which prohibits a lawyer from making extrajudicial statements which may interfere with the pending case in court. And that's about trial publicity. And so the lawyer, it's not right for the lawyer to come out of the courtroom, for instance, and then start to give press conferences talking about the case and, speaking on matters that the court is adjudicating upon, especially with a view to maybe generating some sort of public sympathy or trying to influence how the court adjudicates in one way or the other. Rule 33 of the RPC prohibits that. Now, under Rule 45, we have rules governing how the lawyer is supposed to be dressed in the court. Of course, when appearing before superior courts, the lawyer is supposed to appear in his robe. The only exceptions would be if, for some reason, he's permitted by the Bar Council not to be dressed in his robe, or when conducting his case, or when giving evidence. These are the exceptions in which a lawyer may not be dressed in his robe when appearing before a superior court. Now, we also have under Rule 9, the rule regarding payment of practicing fees. Of course, the lawyer is supposed to pay practicing fees for every year of practice, and the payment is supposed to be made on or before 31st of March every year. But for new wigs, so these are lawyers who've just been called to the bar, and the payment is to be made within 1 month of enrollment. Now, we also have Rule 29, which is a very important rule regarding the change of lawyer. So this is talking about where in the course of a matter before the courts, the client decides to change his lawyer. So he retains the services of another lawyer. Now, you see that the lawyers owe a duty to inform the court properly of the change that has taken place. So under Rule 29, it basically provides that when the client changes the lawyer, the new lawyer is supposed to, first of all, inform the former lawyer of the change, and then make sure that the former lawyer is paid whatever professional fees he's owed. And then if the matter involves litigation in court, both lawyers are required to appear before the court and give notice of the change to the court. And then the former lawyer, of course, has the obligation to return all the documents in his custody which belong to the client. But he may withhold such documents if his fees have not been paid. So basically, he may exercise a right of lien over such documents in order to enforce payment of fees that are owed. So those are some of the very important rules from the rules of professional conduct for legal practitioners in respect of a lawyer's duties to the court.